Okay, we're going to move forward with what has been described as a lightning round. I don't know if that's necessarily the way it's going to feel, because we're going to have so much substance and so many great ideas moving quickly through this room. And we certainly welcome as well everybody watching on the live stream. What we're going to do is have a series of various stakeholders come and share some of their best ideas about where things stand on bail reform and where things need to go. And we'll talk for a few minutes with each of them. And then we believe, if timing works out, we'll have a chance for me to ask some questions and maybe probe a little bit into some of the ideas that they want to bring forward. So we'll follow, I guess, our legislative sort of baseline with some ferment, a lot of different ideas, and then you'll get the factual. In the second plenary, you'll hear more about the sort of the facts and where they're taking us. So first up, we're going to hear from people on very different sides of this issue, from very different perspectives. First up, though, we're going to hear from Jim Quinn. He's a senior executive district attorney in the Queens District Attorney's Office, or he was for a long time under Judge Brown. And he's got some things to tell us from his perspective about where things are. Oh, there he is. Come on up, Jim. Good to see you. Thanks for being here.
Thank you very much. Nice to be here.
Yes. Well,
nice to be anywhere, actually.
Well, something I've mentioned as I often do on panels is we urge people to talk not necessarily from their professional title or what position they're expected to take, but just as a New Yorker, somebody who's thought about this stuff and has a great deal of expertise. Where are we on bail reform, and what are some things that you think needs to happen?
Well, I think, first of all, you're going to hear from me what you're not going to hear from any of the other panelists here in this lightning round. I think bail reform was a terrible mistake. And I think it was based on a bunch of false assumptions, first of all. It was based on the notion that the people on Rikers were there for minor offenses with minor criminal records simply because they couldn't make $500 bail. It's not true. The people who were on Rikers charged with nonviolent felony offenses or misdemeanor offenses had an average of 15 prior arrests, 8 of them felonies, 7 of them misdemeanor, and 2 failures to appear. That was the population that was the target of the bail reform. Those were the ones who were going to be released under bail reform. When bail reform was passed in April of 2019, there were 7,800 people on Rikers Island. By January 1st of 2020, that population had been reduced by 2,000 people, all at once. And all the people who were released were almost every drug dealer in New York City, almost every car thief, every burglar, a lot of robbers, anybody charged with grand larceny who was only in on bail. They were all released at once. And what happened, once those people were released, crime in New York City started its rise. As of November of 2019, before those people were released, crime in New York City was down 1.7%. 2.5 months into bail reform, crime in New York City had gone up 20%. And it had gone up in robbery, went up 18%, felony assault went up 10%, burglary. And you got to remember, every person charged with burglary was released from Rikers Island by January 1st of 2020. Burglary went up 26%. Grand larceny, every person charged with grand larceny was released from Rikers Island. Grand larceny went up 15.8%. Auto theft, every person charged with auto theft, auto crime went up 68% in just the first 2.5 months of 2020. And that's after crime declining in almost every one of those categories in all of 2019. The fact of the matter is that bail reform has been a disaster for New York City. I know there's a lot of talk about how it affected violent crime. The crime that really got affected in New York City was the nonviolent crime, and the petty larcenies and the misdemeanors have just been increasing in New York City because of the people who are released.
And what does that mean for public safety?
It means that more people have their cars stolen, more people have their houses burglarized, more people have their telephones stolen while they're sitting in a restaurant, more people have their kids have their telephones stolen from them on their way to school. It has an enormous impact on public safety. It has an enormous impact on the quality of life in the city. Now, another thing I wanted to get to, I don't know if you're going to ask me the question, but I've only got 5 minutes, so I want to get it all out.
Have you say, absolutely.
There's a lot of talk. In fact, State Senator Cousins says that only 2% of the people who are charged with a crime get rearrested for violent crime in New York State while their case is pending. Now, that is technically true. And there were 284,000 people arrested in the 18 months of the bail reform. And I think it's 5,600 of them were arrested for violent felony. And that is true, and that comes out to about 2%. But what you have to understand is that the people who are impacted by bail reform are the repeat offenders charged with nonviolent crimes. Those are the people who were released. It is not that the person is arrested for shoplifting at a Duane Reade for the first time. Bail was never set on those people. Even the second or third time, bail was never set on those people. People charged with nonviolent felonies very rarely had bail set on them unless they had extensive records or failures to appear. That is a fact. So when you look at the people in New York State who are in what's called non-monetary release, which is, under the bail reform, the state set up a system where a judge, if a judge found that a defendant was likely to not appear, the judge could order him into non-monetary release, which means that the judge would set conditions on his release. It was essentially to replace bail. And if you look at the defendants who were put into non-monetary release, now judges found that they're at risk of flight, and you look at those defendants who had prior convictions or a pending case, those are the people that would have had bail set in 2019. Judges would have set bail on those defendants. The recidivism rate on those defendants charged with burglary in the third degree, which is commercial burglaries, was 70%. Grand larceny, 70%. Robbery in the third degree, 70%. Robbery in the second degree, 46%. Criminal contempt, 65%. Criminal possession of a controlled substance in the seventh degree, 47%. Petty larceny, 79%. 79% of the people put into the non-monetary release program got rearrested while their case was pending. Menacing, 46%. The bottom line is that bail reform, whatever you want to say about the old system, the criminal justice system in the past brought crime down 76% in 27 years. It brought down the population of Rikers Island by 60% during that time. And yet we're constantly told that the criminal justice system was broken and it had to be fixed. This is not a proper fix. It is endangering the people of the state of New York. And the statistics, if you look at them honestly, not looking for a way to justify your position, but look at them honestly, it shows that the bail reform laws and the people who have been released under them are committing the crimes that are causing the crime rise in New York City.
Okay, before I let you go, because we are out of time, but no, that's fine. But what would be the proposed fix? To talk like a lawyer for a minute, even if everything that you say is true, if the legislature in its judgment and the public, which will put them there, has said, you know what, as awful as the outcome might be, a repeat shoplifter is better than somebody rotting in Rikers Island for $500,000 a year. What would be your answer to that?
Look, first you have to decide what is important for the city. Is it important to keep the streets safe? Is it important to protect people? And if you come down on that side, you have to say that we have to have a system that allows a judge to look at a defendant and look at his record, look at the crime he's charged with, look at the evidence against him, look at his background, and determine this individual is a danger if he's out on the street. And whatever you want to call it, you want to call it a dangerous standard or the risk of reoffending standard or whatever. I am remanding this defendant because he is a danger to society. Mm-hmm. And there's really, if you do that simply, it takes away all the arguments about poor people get kept in jail and rich people get out. It offended me as a prosecutor that Harvey Weinstein was outed, pending his trial.
Sure, sure. I mean, that same standard, do you think would have applied to Harvey Weinstein?
Of course.
Yeah. Okay, very good.
All right.
Thanks a whole lot.
Thank you.
Okay. Okay, our next person is going to be, I think Alice Fontier is next, the Managing Director of the Neighborhood Defender Service of Harlem. Good morning, how are you? Yeah, exactly. How are you?
I'm okay. Thank you for
Good.
having me.
Yes.
Glad to be here.
What do we need to do?
So I'm trying to reduce my emotional response to what I just heard. In the last 17 months, 20 people have died on Rikers Island. 20 deaths in 17 months. That's pretrial custody. That's pretrial custody in New York City. The boat, the now defunct Tombs, Rikers Island, these facilities, over many years of dysfunction, have become nothing short of a torture chamber where people are consigned to languish for months, for years, waiting for trial or death. And death comes faster. And many of those 20 people chose their own death rather than sit in pretrial custody in this city. So let's go back and talk about bail reform. The goal of bail reform is now and always has been to reduce the number of people who are held pretrial in this state. By that standard, bail reform has worked and is working. Every time we roll it back a little, it works slower, but it's working. About 10,000 fewer people across the state each year are held in custody pretrial, post-bail reform. 10,000 people a year. 10,000 people who are free to go home to their families, to go to work, to go to school, to seek treatment if that's what's needed. 10,000 people a year who are free to live. And I mean that literally, free to live. Those are the stories we should be hearing. The 30,000 success stories is what we should be talking about. Every single family who had their loved one at home should be on this stage talking about how their lives are stable, how they're succeeding, and how bail reform helped them. But we never hear those stories. We never do. Instead, what we hear are these public safety statistics, which are supposed to be honest. But let's talk honestly, please, let's talk honestly about the facts and the statistics. Prior to bail reform, 95% of people who were awaiting trial did not get rearrested. Post-bail reform, and each year post-bail reform, 96% of people who were awaiting trial did not get rearrested. It is just not true that bail reform had any impact on rearrest rates. It is a false statement. It is a false statement designed to scare you, to raise fear, and it is politics and nothing more. The discussion about bail reform has not been based on any facts, on any data. It is about fear and about scaring you. And most recently, the tropes are about gun violence and an increase in gun violence somehow being related to bail reform. There is just nothing true about it. The bail reform as enacted in 2019, as still in effect now, largely left gun cases untouched. If you are on the street with a loaded firearm, you are going to jail. It was true before bail reform, and it's true now. And what we have seen is that judges are reacting to bail reform and increases in gun violence by setting higher bail. So people who are arrested with a gun are held in custody on bail they cannot afford, and they stay there for months or years until they take a plea or go to trial. That is what is happening. So connecting gun violence to bail reform is false, it is misleading, it is designed to frighten you. It is designed to frighten the legislators. And it worked. I'm sorry, I want to just keep going for one moment.
Sure.
What we have seen is this fear-mongering and scare tactics work. Senator Gianaris is correct. We managed to have a supermajority of Democrats despite this, but people have paid the price. And people are not investing millions of dollars in these scare tactics and fear-mongering because it doesn't work. And in our political cycle, where every legislator is up for re-election every 2 years, it means that they are constantly campaigning. And so the New York Post headlines blaring about crime stats and claiming that it has something to do with bail, let's have an honest discussion. John Jay has put together an incredible group of people today. And what my hope is that the discussion today is honest. It is truthful. It is based on facts. If you are someone who opposes bail reform, if you think it was a terrible idea, I ask you to admit that what you want is for people to be incarcerated pre-trial, and you are not concerned about the deaths on Rikers Island, that you are not concerned that the people who are incarcerated are overwhelmingly Black and brown, and that a dangerousness standards doubles down on the racist impact. I want you to admit that and defend it with facts and not with fear. And that is what I hope for today, is that we have an honest discussion.
Let me just ask you real briefly. If we take as fact, let's put aside the gun crimes, things that I think there's broad consensus, nobody wants to see any of that. If some of the statistics we heard from Jim Quinn are true around, say, auto theft, around shoplifting, around repeat offenders on the misdemeanor side of the scale, and it has enervated the public, the voters, enough that they've gotten the attention of elected officials, including judges. Let's not forget judges are also elected, which is where the dangerous standard will start to sort of feel some of that same political pressure ultimately if it were enacted. What should be done about that?
So it is the crime stats that have gone up. As Senator Gianaris pointed out, across the country, crime has gone up. We talk about in New York bail reform as if that's the thing that did it. It is not true that on the day that bail reform was enacted, 2,000 people walked out of jails across the state and started committing crimes. 2,000 people walked out of Rikers. It's not true. But what is true is that in 2020, a pandemic started and our economy ground to a screeching halt, and people had lost jobs, were stuck into crowded conditions and homes, getting sick and dying. Those things are true and may have an impact on crime rates.
Okay. All right. Thank you very much.
You're welcome.
All right.
Thank you.
I'm putting the lightning in the lightning round. Thank you very much. Charlie Billups is next up, the chairperson of the Grand Council of Guardians. For those who don't know, the Guardians is an association of Black law enforcement professionals, sort of the home I grew up in. Good to see you.
Good to be seen. How you doing?
Good, good. Very well, thanks. Okay, what have you, and I should also mention that, I mean, Guardians have a different perspective on a lot of this stuff. You are an association of law enforcement officials, but there are a lot of law enforcement organizations that go in a different direction or reach different conclusions than you do.
Yeah, true.
So tell us about bail. Where are you?
Well, in the idea of the Guardians, the different fraternal groups, it's somewhat of a crossroads. It's like going both sides. Because keep in mind, our organization is community-based. We are here to represent the people too, also where we live at, in these same neighborhoods where we work at, from the different law enforcement agencies. But then on the other hand, we have another outlook of it too, also dealing with the rate in crimes, as Mr. Quinn talked about earlier. But the key thing to all of this right here is that I'll take it back to the bail reform, how I feel, is that the main part to all of this right here, when they created all of this, and not to knock what they did, but it could have been done better. That's probably the best way I would say it, because there was key mechanisms and key people that should have been part of the conversation when this legislation was being put about. Because the thing is now is that we want to see people go home. We want to see people, if they get locked up, depending on the crime now, which is key. We're not talking about the violent crimes. We're talking about the lesser ones, as Mr. Quinn talked about. Those are the ones we need to focus on the most. The saddest thing about that is now when people get locked up, and let's say, I'm taking it from the very beginning. When a cop or a police officer arrests someone, they take them to court. Right then and there at court, it should be some kind of mechanism or something in place where they can determine what the issue is and why the crime was committed, more versus just locking them up and putting them on Rikers. And it's beyond what it is for Rikers. It's about what treatments or what resources that are being allocated to the individual. I mean, whether it's dealing with mental issues or social issues. It could be a problem where a person is having mental problems. He should have been diagnosed the moment he came into court. And then they should have determined whether he goes to Rikers or to a hospital for treatment. Now, let's look at the other side of that, where you got people who are dealing with social issues, whether it's job, financially, housing, rent, whatever those items may be. Nobody never talks about those. Now, and then I'll flip back to the other side. Now, as a law enforcement, we mentioned parole earlier. I remember when the senator had mentioned about parole. It was a deep conversation I had with parole guardians. I have members in the state parole. And they felt that because of the new standard they're coming out now, is that with the parole violators, the way it's set up, it's like a 3-strike rule. I mean, you out on parole, and depending on what you was, if you committed a crime, depending on what the crime is, you don't go to jail. You literally go home. You get out. And then depending on what the second charge is, if you get arrested again while you're out on parole, is determined if you stay in for a short period of time, whether it's 5, 10, 15 days, and then it goes to the 3rd strike. So it's a lot of language that's being put in there, but it's not really defined the way it should be. And then I'll look on that on behalf of officers or police officers, which a lot of my members are. So the thing is now is that it's somewhat of a hurting feeling when we get a call from people where we live at in our neighborhoods saying that this particular person is constantly committing a crime. So the issue is now is that how do you deal with it? Most of the cops are not psychiatrists. They're not counselors and stuff like that. They do their job. But then after a while, it becomes hurting to see the repeat offenders constantly doing it. So you get that part to that too also. So now it leads back to where the conversation should be back at the courts to determine how can we fix this. I feel, from my own personal opinion, is that when this legislation was formed, they should have brought in right-minded law enforcement people to at least give an idea of what was necessary or the pieces that should have been mentioned or put in to fix things.
Were you all invited in to testify?
No, we weren't.
I see. Okay. And it sounds like what you're saying is that you want on the front end, really almost as soon as arraignment, for there to be a range of analysis and possible pretrial diversion.
That would
services?
determine. That would determine the numbers on Rikers. That would determine the person if they need mental issues or they need mental help or whatever resources that can be allocated. The saddest thing about the legislation, they didn't put in any kind of resources for that.
Right. Well, would your recommendation then be that they do so? Because changes, this is a fluid situation, right?
It's a great need for it. Mm-hmm. It's a great need. I give you a good example. Right now in central booking, in most of the courts or the arraignments, when a person get arrested and if they injured, they're being seen by EMS, and then they are forward to go to the hospital if it's a real physical injury. Mm-hmm. Those same kind of resources should be put in place if a person have mental issues.
Got it. Addiction treatment and so forth.
True.
Yeah, got it. Okay, very interesting. Thanks very much.
My problem.
More food for thought.
My pleasure.
I am liking this lightning round. Kevin Sylvester is the chief of police of the Ossining Police Department. And having grown up in New Rochelle, I'm familiar with Ossining and the southern, close-in Westchester suburbs. Good to see you, Chief. Thanks for coming.
What's going on?
Yes. Bring us your perspective on bail reform, some things that we either need to know, some things that need to change in the law, and how it's affecting your town.
Sure. So first, I just want to start and say I'm not here to argue one side or the other in this. I think that's the biggest problem we've had with the legislative process. The gentleman mentioned not being invited to the table, and that's something that the state chiefs has really been big on. New York State Association of Chiefs of Police is getting that invite and being able to be a part of this, not necessarily to have our way. I'm not a member of any association that spends money on elections or anything. We're simply a bunch of law enforcement professionals trying to make a difference. You know, if I can offer one thing to the conversation, something we're advocating for is the removal of cash bail altogether. We would love to see a situation where the bench has the opportunity to make a decision, and if the remand has to happen based on the standards the legislature sets, then that's given. Because the reality of the situation is, you know, I've been doing this for a number of years now, and what I watch is judges walk in and say, can you make this amount of bail? And sometimes they're setting bail. You know, if you say, can you make $500 bail, and the person says, yeah, but this is somebody in poverty, that's very different than you or me walks in and says $500 bail, and we're career people, and you know, that's not going to stop us from eating this week.
Right.
So it's not just about the people that we're putting, and with all due respect, Rikers Island isn't an issue for me necessarily for my agency, and a lot of what's been talked about is New York City. When I talk about criminal justice and the issues affecting my community, I'm in a majority minority community and surrounded by the ultra affluent. I live in my community. My kids go to public school. This is very, very, very personal to me. The people I arrest, I know by first name, and I see them in the grocery store on a daily basis. I want to see everybody go home. I want to see everybody successful. I didn't come here to debate statistics, but I will say I agree that there's a very small percentage of people reoffending. That's the ones we really need to focus on. If there's really people that we see, the biggest problem in my community is not gun violence, and I understand that's an issue in New York City and it needs to be addressed. I've got 2 or 3 people that I can tell you by first name. One of them was in my 7th grade class. We let them out, they're reoffending before the day's over. And they tell us, I'm going back out and doing it again. And unfortunately, they're at a place in life where they need treatment, they're not willing to get that help, and I'm not really sure what else we can do as a community. I completely agree we need pretrial services. You know, much of this problem will be solved by community building and not necessarily by whether somebody goes to jail or not. So, you know, my passion is really not necessarily in the issue of who goes to jail. I've never celebrated arrests or numbers. I probably haven't made as many as most of my colleagues. But my successes have been in the kids that didn't end up in that arrest or made that first arrest and rebound from it.
Sure. Well, you know, it's interesting because, and something I think everybody, Jim and everybody else would agree on, is that there's a relatively small universe of people that we're talking about. And you're saying, like, in your case, you actually know them by name. I participated in some of the efforts that they were doing in Kings County DA's office about a decade ago, where they would bring people in. They would bring in people and they're like, look, we know who you are, and we're not going to arrest you today or anything like that, but on this wall are our prosecutors, and on the other side of the room are social workers, teachers, therapists, addiction treatment. Just pick which side of the room you want to be on. I mean, is that compatible with this conversation about bail, do you think?
I really hate this idea of walls and sides and different things, you know. I really try to preach to the kids in my community, and kids, young adults, right? I feel like I got old enough to say that now.
They're kids. Yeah.
They are kids. It's more, that was more a statement on my own age at this point. But, you know, the kids that I really love in my community are kids that are getting themselves into either in trouble or not productive or whatever it is. Some of them are just failure to launch, right? And they're not getting out of mom's house. And, you know, we're trying not to say, the prosecutor's over there and the help is over here. It's, hey, we're all kind of here together. So one of the things we do in our community is block parties. Well, we'll bring in resources and trick people in with food and introduce you to things like that in an effort to avoid those situations. I mean, ultimately, yeah, the speedy trial thing is a huge deal. Nobody should be sitting in jail for a year waiting for anything. Nobody's for that. I don't want to see anybody go to jail. I'd prefer nobody goes. I think there are a very small percentage of people that are determined to get out and do it again for mental health reasons, for addiction issues, for whatever those things may be. That's the narrow group that needs to do it. In terms of how the legislation has gone, I think that it's overplayed at this point. I think that we've overcomplicated the wording in all of the statutes to a point where I don't know where to go from here. But I think that's what happens when you get a hotly debated topic, and it's going to be really difficult to find what's right.
If one of my colleagues in the media came to you and put a microphone in front of your mouth because there was a case in your jurisdiction where somebody who was out on bail and was a repeat offender did something terrible, what would you say?
You know, it's tough. It really depends on the circumstance. So in law school, they told us the answer to everything is it depends. So there you go. You know, it really depends. My policy in my department, I do all of our public information myself. It's something I'm very passionate about. I don't release mugshots ever. I think maybe one for a homicide was the only one I put out. I don't release names of anybody. I'll mention that you're how old and from what community, perhaps, in order to help people understand that it might have been somebody coming from somewhere else that did this, or that it's one of our own neighbors. It's something that irks my residents because they'd like to know who the people are. But in terms of your criminal history, the fact that you've offended in the past, unless that prior instance is related to the current one, we're not talking about that. And, you know, that comes from a place of love because I was trying not to weave this one in. You know, there was a kid that grew up in my community who became one of my best friends, and I sat in the hospital and held his hand while he died from violence in the street, and it was a situation he put himself in. You know, as he began getting in trouble as a teenager and young adult, I looked at the situation and said, I don't want people to know who this is. I want him to have his chance. He will get past this. He's going to kick this habit. He's going to find his way. He's going to get a job. Everything's going to be okay. And for him, it wasn't. And, you know, I still spent a lot of time with his friends, but it's really meaningful to me that we've got 25, maybe 30,000 residents. If you get arrested here and I stick your picture on Facebook and 12,000 people follow me, you're never coming back from that. You're never getting a job, primarily because in a low-income community, these folks don't have access to transportation. It's 2022, and I know kids that their family hasn't had a car in generations. And public transportation is not what it is in the city. It's tough.
Right.
So if I put your picture out there, I put your name out there, you may not get a chance to get another job. So to me, it's that, right? This is so much deeper than bail or no bail. I mean, I understand that's why we're here, and that is a really meaningful issue, but I think that people have to look at the totality of this issue and say, what else are we doing? So I didn't put you in the jail. What else am I doing during that time to try and help you? Are we sending out, Westchester starting mental health crisis teams now? We're going to have one embedded in our department responding on calls with the cops. Are we sending people for follow-up after somebody has an incident, arrested or not? Are we reaching out to the kids that we know are most likely? Are we talking to, do our schools talk to us? Are we talking to our schools about, you know, I know right now my 8th grade class is very challenging, and in 3 years we're going to have a bit of a problem if we don't do something now. So what are we doing? We're investing in the 8th grade. Wow. That's where we're putting our time and energy. You know, I think that this is community building, and that's really where this gets solved. I mean, we can talk about bail, and I think that there, with adjustments, eventually we'll find our way on this issue. But I think that if we don't look at the totality of this, we're gonna miss this altogether.
Okay, thanks very much, Chief Sylvester. I'm not the only one thinking, it's like, how do we get him into the NYPD? Maybe get him down here in the city or something. Thanks a whole lot. Latrice Walker is here with us, one of the mothers of bail reform, I would say. Great to see you.
Thank you, Errol. It's great to be here.
Okay. As we've been going through this lightning round process, we invite people and give you 5 minutes to introduce some ideas that you think we need to focus on, things we need to know, changes perhaps to either the process or the law itself.
So, Errol, I'll start with the end. Most recently, we made some changes to bail reform, which includes this statement about harm. But there's no place in the criminal law and the penal code that discusses harm. And so, again, we're throwing in terms without any real definition. We have physical injury, we have serious physical injury, but there's nothing about harm. And then there's this conversation about theft of services. What really does that mean? Now, does it mean that jumping a turnstile becomes bail eligible and people should be incarcerated pre-trial because of that? And then there's a conversation about looking at all of these different factors of seriousness of the underlying allegations, which again are allegations. This was already considered in the 2020 iterations of the changes, where we could look at the history of a person's rap sheet, for instance. And so to a certain extent, some of it was window dressing. And I think it came on the backs of individuals who need the support of the state the most. Just recently, there was a defense attorney who had to defend someone for stealing toothpaste. And in his iteration at that time, he said, well, hey, I needed the toothpaste. And we did something that says, okay, well, we're going to exclude crimes of poverty. But what is that exactly? Because poverty permeates through every element of crime. And again, as most people know with me, the Constitution indicates that slavery was abolished except in the case of criminal punishment. And so when a person is subjected to a crime, they are returned back to slavery in the truest sense. And that's the conversation that we're talking about. This is a modern day civil rights issue. And when people recognize it as such, instead of talking about the fear mongering, then we're going to be able to address the real underlying issues. They need to put more money into cure violence, because we know that the safest communities have the most resources and not the most police officers. And quite frankly, I'm in search for truth and justice. And when people in law enforcement have these conversations, I want them to tell the truth, that there is no connection. Every serious study has indicated that there's no connection between bail reform and the rise in crime, because crime has been rising all across the country due to this pandemic and people losing jobs, people not having access to mental health care or resources or their homes. These are the things. These are the things that are driving up crime in our community. And so I want them to stop making these determinations without any empirical evidence to support any of the data that they're talking about. And so
I've seen, I mean, we talked earlier with Senator Gianaris, and I've seen and talked with enough of you on and off camera to know that there's a certain amount of frustration that political facts come into existence, and then you kind of have to deal with them because that's the political reality, especially in the current election season. And this is really a nationwide phenomenon as well. To the extent that the pressure to make some kind of concessions, changes, rewording, tweaks, whatever anybody wants to call it, to the extent that that's in front of you, what's your inclination to push back against it, to do what legislators do, which is find a compromise? What do you think is going to happen?
So I have a zero tolerance on the implementation of a dangerousness standard. For that reason, I went on a 19-day hunger strike to make sure that we don't just take bail reform back to 2019, but take it to a place where it has never been before. Right now, they talk about these algorithms. What are these algorithms? The CJA asks a few questions. Where do you live? How long have you lived there? Where do you work? How long have you worked there? How many years of education have you completed? All of those questions go towards a person's propensity towards poverty, not dangerousness. And so again, we have to be concerned about the criminalization of poverty. And by extension, most people who are living in poverty are Black and brown. And so maybe that's why there's a correlation between race and incarceration. Who knows? But either way, I will continue to fight back against that. One of the things that I will be doing is introducing legislation to define harm, to define what theft of services is, so that we can have a bill that our judges will continue to be able to understand. We gave them more tools in their toolbox than they had before, even though they were saying we need to give the judges discretion. They already had discretion, but they never had discretion to say, you need to go to a substance abuse counselor. You need to go to a housing counselor. You need to have support services for housing and eviction. And these are some of the tools that we gave them, but we have to put our money where our mouth is. And so we'll be calling on the governor as well to put the resources behind so that we can have our judges be able to lean on the community-based organizations that we know will help us in our ultimate goal of public safety.
It's startling to me to see that things like, harm or say harm to property, which is something I don't even remember.
How you harm a property? I don't know.
Well, I was going to say,
sorry, property.
I missed that part in law school, right? But but if it's there, it's going to generate some case law, and the definition will sort of evolve, and you all can put some shape to that as well. But
Right.
I guess the challenge is that takes time.
But the beauty in the way that our founding fathers set up this great country is that there's a separation of the judicial branch, the executive branch, and the legislative branch. And we must all work together, but we are checks and balances on one another. And I appreciate the judges leaning on the legislature to say, these are some of the things that we need to have. But when you go too far, again, we will continue to put forth legislation that will define this thing, that will also deal with public safety, but will also recognize that we can have public safety, but not at the consequence of our civil and human rights.
Okay, thank you very much.
Thank you.
Last but not least in this lightning round, Akash Mehta is the editor-in-chief of New York Focus, and they, of course, have been covering this like all of the rest of us in the media. Here he is. Good to see you. How's it going?
It's going well, thank you.
Okay, let us know. Lay it on us. You got 5 minutes.
Great.
He knows what 5 minutes means.
Yeah, thank you so much for having me. So bail can, I'm telling you nothing new, bail can be extremely hard to cover. There's almost no subject that's more emotionally charged, and there's almost no subject where that receives so much attention, but where there is so much disagreement on basic facts and misinformation on basic facts. We've talked about a few of those, and I think the next panel is going to talk about a few more, including going deeper in the oftentimes counterintuitive relationship between pretrial detention and crime. We've talked about the legal purpose of bail and how that's been misunderstood. I hope future panels will talk about the often ignored requirement on judges to consider the defendant's ability to pay in setting bail, which they often don't. I want to touch on something else which can seem a little wonky, but I think has both major implications and I think has lessons for this conversation at large. And this is a lesser-known part of the 2019 reform law that had transformative potential but has largely not been implemented. And that is that the 2019 reform law, in addition to restricting the set of cases in which bail could be set, also in those cases in which cash bail is set, required judges to, in addition to setting cash bail and to setting, in addition to setting cash bail, they were supposed to set 2 other forms of bail. Traditionally, this is cash bail, insurance company bail bonds, and then a third form of bond, which is usually something called a partially secured bond. And these are bonds in which the family members or friends of the defendant acts essentially as the insurance company bail bondsman. And the family puts up a refundable deposit. Usually it's set at up to 10%. Judges usually set it at 10% of the PSB amount. And so the way this worked before bail reform, so before this was required in every case in which cash bail was set, is that, let's say cash bail was set at $10,000, the judge would also set the insurance company bond at a certain amount, and then the partially secured bond, when they set it, would also usually be set at the same amount as cash bail, so $10,000 again. And then the family member, the defendant, let's say they can't make a $10,000 cash bail, almost none of them can, but the family member might be able to scrounge up $1,000 to put as a deposit. And so when this was set before bail reform, the rate at which defendants could make bail increased by literally 5 to 6 times. And at the same time, the failure to appear rate stayed at pretty much the same. Mm-hmm. So people were returning to court just as much, but getting out far more often. Once bail reform went into practice, and this was required in every case in which cash bail was set, judges responded by jacking up the prices of this PSBs. And so now you have a typical case where if it's 10,000 cash, it'll be 60,000 PSB. And then the family might not be able to make the deposit. And in fact, I ran the numbers on this recently. In 1 out of 8 cases, the judge sets the partially secured bond at so high a rate that just the deposit is higher than the cash bail amount, which essentially means you're not
Yeah, that's perverse, right?
you're not offering a PSB at all.
Right, right.
And so this is exploiting a loophole in the law to essentially not follow this part of the law. And that's largely, interestingly, that's largely because of, I think half of all those cases come from just 25 judges. At least I think that's the case in New York City. So for instance, Eugene Guarino here in Manhattan sets this deposit higher than cash bail, ignoring the intent of this law, exploiting this loophole in 94% of cases. And so this is an area where, and then at the same time, judges often, when families can scrounge up the amount for this deposit, judges often, and we've reported on this at New York Focus, judges often will reject the family member because they say they can't come up with the full amount of money. The legislature didn't authorize them to do that. It's a gray area. I'm not in the business of making recommendations to legislators, but I do think it's an important part of the law that has not been revisited, is not being implemented, and deserves some more scrutiny. I think the last thing I'll say on this is that defendants and their public defenders oftentimes do not know about this part of the law, even though if it was implemented fully, it could get them out at 5 times a higher rate. And so this is an area where I think we in the media have really failed in discussing this, in educating legislators who often don't know about this either, in educating judges, and in educating
I am hearing about this for the first time, so I thank you for educating me. It's a reminder, by the way, that many judges are themselves elected officials and have very different ways of interpreting the laws, including this set. So you said there are about 25 judges that are sort of using this differently than a lot of their colleagues.
who are most responsible. Yeah, and I do think across elements of this law, you see, we talked about it a little with the harm statute. You see, essentially what bail reform did was limited judicial discretion, and that's why you have that 10,000 figure of 10,000 fewer people incarcerated. And with the PSBs, we saw that there was offered a little bit of discretion, and some judges, certainly not all, used that discretion to essentially ignore this law.
Before I let you go, the challenge of trying to make this clear to your audience, how are you handling it when people sort of say, as they do, and it's an election season, so some of this is politically charged for a reason, where people say, XYZ happened and bail reform is to blame. And as far as you can tell, that's not necessarily true. How do you handle that? Because the sentiment and the political reality of it is true. The underlying statistics may be fudged, inaccurate, or frankly made up. But so you've got an element of maybe political truth and statistical, doubt or question.
Right.
How do you handle it?
I think there's a question of how do you respond to inaccurate statistics, and I think that's hard, and I think you just have to put it in context, and especially hard when there are, it is certainly true that there are incidents in which people are released from bail and commit crimes after they're released from bail. I think one thing that journalists need to do more is put into context the larger number of cases in which people the ways in which pretrial detention can drive crime up as well. And and I think the next panel is going to talk about this, misdemeanors, which is largely what we're talking about. There's really robust data that shows that pretrial detention generally increases the rate of new crimes by 12%. That was based on a New York City study. And I think we need to both make that part of the conversation and then also highlight the stories. So we recently Sam Mellons, who writes for us, recently wrote a story about someone who left Rikers, was homeless, violated a protective order because he was bouncing around between his family members for a few weeks, didn't have a place to go, and so ended up at his former girlfriend's apartment, violated the protective order, was sent back to Rikers, and that is a case that illustrates how when you disrupt people's access to housing, access to employment, access to jobs, that also has to be part of this public safety conversation.
I've seen very little reporting along those lines, although a lot of the criminologists I've talked to have described exactly that. Maybe something that we do need to spend a little bit more time on. Thanks a whole lot.
Thank
Good
you.
to see you.
Thank you.
I think that brings us to the end of our lightning round. I will get off the stage. Thank you all very much. Okay, yeah, panelists. Mr. Quinn, Mr. Mehta, come on up. We have time for some questions, and there are some questions out there. Right, we have mics that will circulate. I thought I had run out of time, but we did not. We've got a good 15, 20 minutes here. If you have a question, you should signal. A microphone will be brought to you. Yep, Mr. Billups. I mean, I've got more questions. I'll ask them for you if you want, but put a hand up if you'd like to direct a question to any member of the panel.
You might as well fire away.
Yeah, really. Okay. Yeah, I'll get us started. I think I am most curious, Assemblywoman, about this whole question of making changes because something has to change. How would you characterize what just happened in the last session? Because there were changes made. The governor had insisted on them. And then right behind it, there were critics who said those changes were meaningless or those were symbolic, that they were only there for show.
Well, we watched circumstances where politics were more powerful than people. We saw a process that was hijacked with respect to changes which were proposed in the 99th hour as opposed to being in the governor's budget proposal initially or being in the 30-day amendments or at any other point, but instead they came 11 days prior to us having to finalize the budget. Many other things that we should have dealt with respect to healthcare, education, et cetera, were held up based on criminal justice reform. We were just saying that people needed to have access to discovery prior to the eve of trial, and that young people who are 15 and 16 years old just doesn't have the brain development, and the doctors and medical evidence shows that they should not be charged and or convicted as adults. And so it was a sad situation. We saw the fear-mongering. Even though the police commissioner, the previous police commissioner, came up and himself testified at a hearing that there was no connection to people who were being rearrested for the shootings and bail reform. Despite the police commissioner's commentary, we still heard the fear-mongering coming out of the police department saying that there were serious connections. And so, again, we are still in search for truth and justice. This will continue to be a conversation that we will debate. But again, you know, I'm glad that we were able to make it through, but we are not done yet. Quite frankly, the day after the budget was completed, we had a codes committee meeting where there were Republicans who were putting repeal bail reform right back on the agenda and many other changes to bail reform right back on the agenda. And so we may have crossed that bridge on April 7th or 8th, but we still have a lot more work to do.
Got it. You know, Mr. Quinn, I want to ask you to, I guess, think about some of the politics of this, right? You gave a very, you know, sort of statistical, legal, prosecutors, based on your experience, analysis of what has happened in the months since the bail reforms were enacted. There are political people, there are politicians who are using some of that data, some of those arguments very differently, saying that, you know, this or that district attorney should be removed, you know, that the laws need to be changed wholesale, that a dangerousness standard needs to be enacted, although New York doesn't have much of a history of that. Do you worry about your analysis being used in ways that maybe goes beyond what you think the facts will support?
My analysis is based on facts. It's based on data that is available to everybody on the OCA website. Everybody can look at it, every state senator, every state assemblyman, everybody. What I'm concerned about is that the entire discussion about bail reform is not based on statistics. It's based on anecdotes, it's based on feelings, it's based on general principles, that are on both sides, that are very difficult to debate. And we're here talking about bail reform, but there are a whole series of things about the criminal justice system that have to be reformed. And bail reform is just one part of the issue. That's why all my discussion points are geared toward bail reform. But there's also alternative sentencing reform. And when I was in the DA's office in Queens, we had dozens of programs that we put people into. I'll give you one example of one of the effects of bail reform. When I was in Queens, we had a human trafficking court. Every defendant arrested for prostitution went into the human trafficking court. In that court, we had social workers, we had clinicians, we had psychologists who would talk to these people and try to get them out of prostitution. 400 cases in there. Once the police department stopped arresting people for prostitution, that court went down to 20 defendants. So it's not like prostitution stopped. It's that all those people who are getting treatment no longer get it. Another aspect of bail reform, there's talk about how judges can mandate somebody go into treatment. Yeah, they can, but if it's a non-bailable offense, if they don't go into treatment, the judge can't do anything to him. He can't remand him. He can't put him in. He can set higher, conditions. You have to report, instead of reporting twice a week, you have to report once a week. But if he doesn't, well, then you say, okay, now you have to report every day. And he doesn't. He cannot put him in. The judges have lost all discretion and all authority in the courtroom as far as the defendant's actions while he's out on bail. And, there are all sorts of issues. Now, I wish that, we could discuss more of this in a more generic platform.
Well, it sounds like, among other things, you're saying that, an arrest and an arraignment should not, say in the case of sex trafficking, be the front door, right? I mean, if it takes an arrest to trigger all of this potentially good stuff that's out there, we've got the wrong set of institutions dealing with a particular social problem.
But there was nothing to replace it. There was nothing there was nothing to compel them to go into treatment. There was a lot of the women in those programs, they didn't know where to go. A lot of them were foreigners. A lot of them were immigrants. A lot of them are battered women. Where do they go once they're out and they're no longer being brought into any kind of institution, any kind of institutional setting?
Sure.
And that's true with so many different things. The drug courts are losing people. The overdose rate in New York City has gone up. But we don't talk about that stuff. I mean, in New York City, because of the discovery reform, 80% of the misdemeanor cases in the Manhattan DA's office last year were dismissed. 80%. That's up from about 15 to 20% the year before. And it's the same thing in every DA's office in the city. That they cannot comply with these things, and these cases are being dismissed.
My question is for Mr. Quinn. So I see a lot of your presentation was based on the fact that crime has increased because of bail reform. And I'm just curious as to what you think happened across the country, where states that did not enact a new bail reform, like what happened there? And a follow-up is, what impact do you think the economic devastation from the pandemic has had on the crime rate?
Okay, I never said that bail reform was the sole reason for crime going up in New York City. I said it's a substantial reason. New York City has always been an outlier with respect to crime. Crime in Chicago has been going up for years. Crime in other cities around the country has been going up for years. The numbers that I gave were numbers of the crime rate before COVID hit. They were the first 2.5 months of 2020, which the numbers that I gave ended on March 15th of 2020, which was before the city started closing down, before COVID became a factor. And in those 2.5 months is when crime in New York City went up 20%, just in those 2.5 months. Whereas in the year before, 2019, crime had gone down. And crime went up in every category for which defendants had been released. under the new bail laws. Now, it wasn't 2,000 defendants were released on one day. Those 2,000 defendants were released between November and January of 2019. And in 2020 is when crime started going up. It's more than a coincidence. As a friend of mine once said, I believe in miracles, not coincidences. And you can't tell me that releasing 2,000 career criminals from Rikers Island in the space of 2 months had no effect on the crime rate in New York City. That just doesn't make any sense.
I definitely have a question.
I should, okay, yeah, I would, when you say crime rate, you mean the arrest rate, right? That's what you're talking about?
Sorry?
You're talking about the arrest rate in those months, right?
No, I'm talking about the crime rate.
Yeah, but then
The crime rate in the first 2.5 months
Right.
of 2020 went up.
Was there a question over here?
Thank you all
Oh.
for your thoughts today. I just wanted to ask maybe a point of clarification or just an expansion on something. We've heard a lot of talk about speedy trials, but we all know that most cases don't resolve through trial. So I'm wondering if any of you can speak to how bail reform has impacted plea dynamics and how negotiations take place for pleas.
Good question.
Thank you.
I'm happy to address it. It's a very good question. In bail, but it's answered both by bail and discovery, which has had the greatest impact on plea negotiations and how people are handling their cases. We have not seen an uptick but for the pandemic, in the length of time it takes to resolve a case in terms of negotiating a plea. Getting to trial throughout the pandemic has been basically impossible. They were shut down. But people are making decisions based on information. They are free to make these decisions not because they need to get out of jail, but because they are at home assessing the information that has been provided, the evidence in the case, and they are making informed decisions about whether they should take a plea or not. What I will say, though, is that the greatest impact of bail reform on pleas relates to misdemeanors. Because what would happen prior to bail reform is that a judge would either threaten or say they were about to set bail, and the person would plead guilty to the misdemeanor at arraignment, at the first appearance, with no information other than a complaint. It happened in one shift. If I was working arraignments, I would represent 10 to 15, 20 people in a day that would take a plea to a misdemeanor at arraignment in order to not go to jail. And so again, like when we talk about public safety as a whole, somebody who has been charged with a misdemeanor never was going to jail, but they were taking pleas to avoid it. And so you walk out with a criminal conviction, instead of just walking out with the ability to, assess services, determine whether or not you should take a plea or not. All of those things is ultimately how this has been impacted.
Can I also just add, too, that a lot of this is cultural, right? We've seen the movie with the Exonerated Five, where one of the young men, his father said, just talk to the police, and they're going to let you go home today. A lot of times there's a belief that if you take this plea, you're going to go home. And so people, of course, again, as you mentioned, want to be home. But there are also many prosecutors who utilize this time as a point of pressure to go on to individuals to say, well, you've been here already for 6 months. Don't you want to go home? If you take this plea, you can walk out the door today. And they'll walk out the door, right? Whether or not they are certain of their innocence or not. And then if they happen to be recycled back into the system, there are individuals who now want to look at that plea, whether it was for cause or not, that will now give them a harsher situation the second time around, even though fear and poverty and misunderstanding may have been the cause of the first and underlying plea. So it's very dangerous territory, we believe.
Okay, sir.
Yeah, thank you. This is actually a question for you, Mr. Lewis, and also for Mr. Mehta, which is, I think, as we see, and I think most of us can agree on, the vast majority of people who are released pre-trial go on to live their life, to be with their families, able to participate in society. And that it's really hard to cover that in the media. And it seems like the media covers much more the sensational fear-mongering stories. So how do we do a better job of telling those stories so that the general public, who politicians react to, can understand the success of the bail reform?
Yeah, look, it is very frustrating and it is very challenging. I mean, the short answer, of course, because one version of that question is why are you guys always covering bad stuff and not good stuff? And the standard answer is, look, dozens of planes land without incident at JFK every day. Do you really want to hear about that? But when one crashes, you definitely want to hear about that. And that's just kind of the nature of the business. So it's a permanent kind of professional challenge. When it comes to this, though, we are understaffed. Local news is frankly understaffed. There was a time when there were courthouse reporters who were stationed in the courthouse all day, every day, got to know the cases, got to know the judges. It would be nothing, or I should say nothing, but it would be relatively easy to write up a story about a judge who at arraignment did something really interesting and creative. I happen to have a very good friend who's a neighbor who is a judge who did something like that, and I wrote about it because I thought it was really interesting. But that was just, I bumped into her on the street and she told me about it. I sentenced the guy to write an essay, and I knew the parents, and he didn't have any priors, and I know the neighborhood, and judges who do a good job like that, it's fantastic, and it goes on every day, utterly without notice, and it is our fault, I think, for not getting to it. I'm not sure what you would say, Akash, but we just don't. We are very, very shorthanded, and then there is, of course, that bias toward an audience that wants to hear about something that they absolutely need to know because it's a man bit a dog and not the other way around.
Well, the Post also in 2020 wrote a story that said that the New York City Police Department claimed that bail reform and recent jail releases had led to increase in shootings. But according to the Post analysis, the NYPD's own statistics proved otherwise, that between January and late June of 2020, according to NYPD data reviewed by the Post, just one singular person released under the statewide bail reform laws had been charged with a shooting.
Yeah, no, I mean, that happens all the time, though. I mean, look, there are public and political figures who say things very earnestly. They look right in the camera. They practically swear on it, and it's completely wrong, right? Intentionally or not. I mean,
Errol, if I can just say something, those 520 shootings, most of them, there was no arrest made at all. So it's not like 528.
But is that a problem with bail reform?
But it's not like 528 people were arrested for a shooting and only one of them had been on bail. And that statistic comes from a New York Post article that is not particularly an in-depth article of the statistics on shootings.
Now, I'm from Brownsville, and we have a huge problem with shootings, and we want to be safe. My brother was murdered at the age of 19, just steps away from our front door. So I get it. We need to do something about guns on our streets. But I believe that when we properly identify the problem, then that's when we can go at a solution. This scapegoating bail is not going to get us to the point where we need to be at with respect to shootings in our community. I'd love to talk to you more about it.
I would love to sit down and talk to you. And I'm not looking to scapegoat everything. What my statistics show that there is a finite group of people who are involved in the rise in crime in New York City, and it's those people who have to be dealt with. And the bail law, as it currently exists, doesn't do that. And when 70% of the people who are arrested for burglary in the third degree and released into the non-monetary release get rearrested, and that's being rearrested for a crime where there's only a 30% clearance rate. So 70% of the burglaries don't even get solved, but 70% of the people arrested for burglary in the third degree who go into that non-monetary release program get rearrested. And those are the people that nobody's looking to put everybody in jail on bail. Nobody's looking to take everybody and just throw them into jail because they can't, because we can do it. I don't know a single prosecutor who wants to do that. I don't know a single person, who wants to do something like that. But we have to look at this honestly. And we can't just sit here and say, well, your statistics are fear-mongering, or your statistics are, are this, or people are dying on Rikers Island. 45 people a year get murdered in New York City housing projects. Murdered, not suicides, not drug overdoses, but murdered. And we don't hear anything about that.
Yeah, good afternoon. My name is Roger. I'm formerly incarcerated, and I've heard, I just got here not too long ago, but I was hearing the issue about bail and discovery. Like, I'm a victim to that. Like, discovery has been law in most of this country for decades, and there has been no over court, none of that. So I don't know why y'all demonizing discovery and why y'all demonizing bail. Like New Jersey have bail reform. You know what I'm saying? And a lot of other countries have it, and it's good, is well intended, is good. I don't believe that if you commit a minor crime first, you're gonna go home and commit a major crime. That's not the case. You know what I'm saying? But especially about bail reform, what was happening before is that prosecutors was doing trial by ambush. They would come on the day of trial when all the juries already was picked, and they would give reams of paperwork to the defendant. How is that a fair trial where the lawyer cannot properly review the documents? He cannot go and do his own investigation to rebut what the prosecutor is saying? Like, how is that possible? And then you're going to complain about discovery as if discovery is something bad. That's really part, I always thought that was part of the 14th Amendment of the Constitution. You should have a right to defend yourself. And the only way to do that is to know the charges against you, to know what the police is saying, what the prosecutors is saying, what the witnesses is saying against you, and for you to be able to defend yourself. So my question to you is, why demonize these things that has mainly, like, y'all have for decades targeted black and brown communities. The vast majority of people that y'all target are people that look like me. And last but not least, a former prosecutor last week, he came up to Albany and he stated that his colleagues, whenever they get a conviction, they celebrate inside of that district attorney's office, which is horrendous. Y'all prey on the poor, and y'all abused us the same way police officers beat us up on the street and kill us like dogs.
You can answer or not if you want. We are at the end of our time, but I do want to hear about discovery reform. And you cited a statistic of a very large percentage of cases, I think, in Manhattan that couldn't meet the new speedy trial clock.
In Manhattan, it's 80%. I know that in Queens, it's about 75% of the misdemeanor cases. It's about 20% of the felony cases. It used to be about 5 or 6% of the cases would get dismissed in Supreme Court. And the reason is, when the discovery bill was first passed, DAs had 15 days to complete all the discovery. And they couldn't answer ready for trial until they had completed all the discovery. And if they didn't complete it within 15 days, there were sanctions that were going to be imposed against them. And the problem with that is that look, in reality, on misdemeanor cases, most defense attorneys know what the story is. Even on felony cases, they know what it is. I can't think of a single case when I was a prosecutor where I walked in and handed the defense attorney a pile of discovery material on the day that the case was going to start trial. And if I did, there's no judge in Queens County that wouldn't have given the defense attorney an adjournment to look at the material and excoriated me for doing that. And, you can have discovery reform that's reasonable, that gives DAs a reasonable amount of time to do it, that eliminates that time from the speedy trial clock, so that that is not counted against them in running their case to trial. The notion that prosecutors are out there just prosecuting people of color for the fun of it it's so shop worn. And you want to talk about fear mongering and just muddying up the debate. Do you know that in New York City, a black citizen is 28 times more likely to be shot than a white citizen. 28 times. 96% of the people shot in New York City are black or Hispanic. And 96% of the shooters are black or Hispanic. I mean, this is the reality that we live in. I mean, and that's why there are more blacks and Hispanics on Rikers Island. It's not because of any, inherent or systemic bias in the criminal justice system.
Let me ask you, Assemblywoman, and this will be the last word. Is discovery reform going to get a second look in Albany?
Well, we did make a few changes to discovery, and part and parcel in terms of how it happened was there was an issue that where the discovery clock was ticking, and prosecutors had to certify that they were ready for trial. But they had not delivered all of the evidence, and there were hearings after hearings after hearings that came to that determination. And after those hearings, if a judge felt like the prosecutor had not met its burden, then some of those cases were being dismissed on that basis. At this point in time now, with the changes that we've made, the judges are able to take a closer look at the underlying evidence which is necessary, and also to be able to determine if it's like smoking gun evidence. Is it something that's going to lead to a defendant being able to prove his innocence? And so there's sort of a balancing test that gets done. Prosecutors were at the table. Defense counsel were at the table, as well as advocates being at the table. And they all, from what I believe, walked away with a negotiation that they could all live with. And so we believe that we may be okay with respect to discovery reform for now. But again, I believe that as soon as we get back to business as usual, everything is going to be back on the table.
And are you concerned? Are you worried about that dismissal rate, the failure to sort of meet the speedy trial clock?
Look, we're lawyers, and we all learn that clocks are important in the law, and there's a reason for that, so that people can go on and continue to live their life if we're not meeting our burden. And it's always important to recognize that as Americans, we are innocent until proven guilty. And if a prosecutor is unable to make their case, that's their burden. And so, I believe in our system. I believe in legal jurisprudence. I love the law. And we all have to respect it and adhere to it, and not allow it to be bent in order to achieve some overreaching goal about a person's visceral response to public safety.
Okay, that is going to be...
Sorry, can I say one thing?
Real quick.
Of course.
It'll be very fast. It is not true that 70% of cases in Manhattan were dismissed because of speedy trial and discovery. A significant number of low-level offenses, misdemeanors, were dismissed in the time period that Mr. Quinn is discussing. But thousands of them were because marijuana possession is no longer unlawful. And then several hundred, probably more in the thousands, were declined to prosecute on consent of the prosecutor because they were outstanding desk appearance tickets during the pandemic, when there was no means of having in-person appearances. And so sitting at a table with us, defenders in Manhattan, the prosecutors went through their list of outstanding cases and made the discretionary decision to dismiss those cases. It was not speedy trial. It was not discovery.
Okay. All right. Please join me in thanking our panel. Great discussion.